Welcome to the third webinar in Kent Law School's Summer of Law programme. My name is Darren Weir and I am a lecturer and former criminal barrister and teach here at Kent Law School, and I convene the Law of Evidence. I'm joined today by three of our final year students, though technically they're no longer students as they're awaiting their results. They've just finished, so we technically call them graduands. So you're not a graduate, you're a graduand, and then I'll ask them to introduce themselves. So off you go.
Hi, my name is Ashley Yarrow, and as Darren said, I'm a graduand. Presently, I'm in Canterbury, but after graduation, I'll go back to my home country of Kenya to continue my legal education for admittance into the Kenyan bar and then do my master's.
Hi everyone, my name is George. I was the former Canadian Law Society president, and as Darren said, I am a graduand. I'm in Canada, specifically Toronto right now, and after graduation, I plan on to continue my legal education in Canada and prepare for the bar so I can practice here.
And what time is it in Canada, George?
It's 9 a.m.
9 a.m, there you go. Commitment.
Hello, my name's Jeremy Kingsford. I'm also a Canadian that immigrated to the UK to practice law. I'm also a graduand. I was the president of the Kent Law Temple Society, which is the one focused on people becoming barristers. I'm going to be continuing my studies at bar school next year to hopefully become a criminal barrister.
Excellent. So today we are posing the question, what is the law of evidence? Firstly, in terms of a subject, it's taught here at KLS as a final year optional module on our undergraduate and our senior status programme. It is a compulsory subject for anyone who wants to be a barrister in England and Wales or an advocate in most common law jurisdictions. It's also a core subject on the solicitor qualifying examinations. So what is it? Well, I could spend an hour talking about that, and I'll just do it in one sentence if I can. In essence, it's the law governing the rules of engagement in our trial process. So any dispute, whether that be civil or criminal, could find itself in court or a tribunal, and so all lawyers have to know what might happen to their case if it did go to court. So I'm going to try and just share my screen here. This works. And really, if you notice in the news, if you've been watching the news or reading the news in the last month or so, there isn't a day that goes by without something being mentioned in the press about the law of evidence. Cases collapse because of the law of evidence, or there are issues at trial. And indeed, last month, we will all remember the very big case concerning the Post Office Horizon scandal, where a number of postmasters were wrongly convicted as a result of the Horizon computer programme. And of course, that was a form of evidence, and it was evidential issues that caused the case to collapse. So let's see how much our graduands remember. Ashley, could you please explain to us what is meant by an adversarial trial?
So the adversarial trial is a system by which disputes are handled by the courts. And in an adversarial system, there'll always be at least two sides to a dispute. And usually the party who brings the action to court will have a complaint of some sort. Like, for example, in a civil case, they might claim that another party has breached an existing contract. And in a criminal case, the state will accuse the defendant of a crime. And so the adversarial trial, it's akin to a boxing match where each side will contest the allegations made by the party bringing the action to court, and the party bringing the action has to adduce evidence to prove their case to the standard required.
Okay, so you say they prove the case. Who are they proving it to? In other words, who is deciding whether the contract is breached or if the defendant's committed the crime?
That's decided by the tribunal of fact, and who that is will depend on what court you're in. In most civil cases, that would be the judge. In that tribunal case, that might be a panel. In the magistrates court, which is actually the lowest criminal court, that would be the magistrates. And in the Crown Court, which tries more serious criminal offenses, that would be the jury.
Okay, so we know who decides the facts in any given case. That's the trier of facts, as you just said. And we know that the person who has to prove the case is the party who brings it. But what exactly has to be proved, George?
Well, that depends on what the case is, right?
Okay, well, let's perhaps focus on a criminal case. George, let's imagine you've been arrested on suspicion of shoplifting.
Okay, now what have I stolen?
Don't know. Looking at you, you need razor blades. So let's say razor blades.
Darren, there's a reason I don't shave, so let's go with something else. Why would I steal razor blades?
Okay, right. Pick something else. What would you like to steal then, George? What do you want to steal?
Let's go with adult diapers.
Adult diapers, right? Really?
Yeah.
Okay. Well, we'll see if anyone asks the question in the chat what you use them for, but putting that aside, let's imagine then that you are alleged to have stolen adult diapers. What does the prosecution have to prove?
Well, that would be the elements of theft.
And where do you find the elements of theft?
Find them in the Theft Act.
And those would be?
Okay, 1 second, you're putting me on the spot. That would be dishonesty, appropriation, property belonging to another with the intent to permanently deprive.
Okay, cool. So the substantive laws, that's what we call the substantive law. And people who are watching, who are thinking about coming to law school, that's the sort of stuff you're going to learn in all the subjects you take. So criminal law, you'll learn what the ingredients are of offences. In contract law, you'll be taught what a contract is, what needs to be in a contract. And of course, negligence, the law of negligence defines what negligence is, and so on. So these become, for our purposes for the trial, these become our facts in issue. All right, these are facts in issue. Now, there might also be other facts in issue. Let's say George denies he was actually even at the shop and he didn't steal the was it adult diapers, the adult diapers. What sort of fact in issue is he putting into play there?
He'd be raising the matter of identification.
That's right, Jeremy. Thank you. Well, good to see you join in. So we know who we have to persuade, the trier of fact. We now know what we have to prove. The next question is, how do we prove it?
So by calling or producing evidence or information that will then persuade the trier of the fact of each fact and issue that it's been proved and that ultimately that George is guilty.
Okay, so essentially, every single piece of evidence or information adduced at the trial will be going to one or more facts in issue. Okay, so let's imagine we're in the shop where the theft happened. Let's ask the viewers, let's ask our audience out there to use the chat, and please feel free to use the chat, guys, whenever you want to, if you've got a question or anything else that crops up. But on this particular little task I want you to do, can you imagine you are in that shop? Think about what type of evidence there might be to help us prove that George stole the adult diapers. So just in the chat then, indicate what might there be in terms of evidence. Let's see what happens. Anyone typing anything? I can't. Here we go. Right, here we go. Because I have to stop sharing to see the chat. So security camera footage, CCTV, excellent, yes. So CCTV evidence, what type of evidence is that, Jeremy?
That'd be classified as real documentary evidence.
Right, so yes, every single type of evidence is categorized. It's given so much weight or whatever. So CCTV footage could be very good evidence, of course. It might, of course, show him actually taking the diapers from the shelf, in which case, what fact and issue will that go to, George, if it catches you taking it? Can't hear me now. Jeremy? Appropriation, taking it, wouldn't it?
Right.
Yeah. So it proves that he's taken it. But what if it doesn't show him taking it, but it just shows him being in the shop? Then That would prove identification, wouldn't it? So it depends on what the CCTV shows in terms of what fact and issue it goes to. What other things have we got? Witnesses. Yeah, so witnesses. Ashley, if we have a witness, say we have the security guard who witnesses George taking the diapers, what type of evidence will they be giving?
The security guard would be giving oral testimony.
Yeah, oral testimony. Good point here from someone. Was George found to be in possession of the diapers? Yeah, if he was stopped at the door of the shop, having gone past the tills, what's the inference that can be drawn about that? Well, he hasn't paid for them. Therefore, did he intend to steal them? Was he acting dishonestly? What else might they do? They might search him. Has he got any money? That's a good point. Has he got any money to pay? What inference can be drawn from the fact he has no money? Well, he therefore went there intending to steal. Yeah, so these are all great stuff. Fingerprints. Someone's actually got fingerprints. Maybe he dropped the diapers, you know, and did a runner from the shop. And that sort of introduces a criminal law aspect of when did the theft happen. So yeah, so all these pieces of evidence are obviously relevant, and depending on what they are, we'll go before the jury. Excellent. So where does the law of evidence come into all this? Well, one of the most important thing for us to mention for today's purposes is that the evidence must be admissible. When is evidence admissible, Ashley?
Crikey, Darren, I didn't think that this would be a memory test.
I know, sorry about that.
Are you? But anyway, there are 5 pillars for admissibility of evidence and their relevance. The evidence must also be of sufficient weight. The probative value must outweigh the prejudicial effect.
Okay.
It cannot be excluded by any exclusionary rule. And the most overriding consideration is it in line with the Article 6 right to a fair trial.
Okay, excellent. One of the ones to go back on there and just quickly mention to people in case they don't follow it. Probative value versus prejudicial effect. So how useful, to probative value means how useful is this evidence? Obviously, CCTV showing George taking the diapers is very useful, isn't it? Is there anything though prejudicial about that evidence? Well, sometimes the judge who will decide admissibility will have to make a judgment call about how probative the evidence is versus prejudicial effect. But as Ashley correctly said, the fundamental right protected under Article 6 of the European Convention of Human Rights is the key to many of the decisions and dilemmas faced in the law of evidence. However, the idea of fairness is not only that of fairness to the defendant. Our students soon learn and come to realise that this Article 6 right is closely associated with other rights. And, you know, something you might think about doing before you start a law degree or come into university is, why not have a read of the European Convention of Human Rights? It's a document that simply contains your rights. So it's not a very long document, really. Of course, there's lots of commentary and everything about it, but the actual document itself isn't that big. And knowing your right, you might realise, my goodness, I didn't realise I had that right. So Article 6, as I said, should be read in conjunction with other rights. And also it applies to witnesses and victims as well as defendants. Indeed, the law of evidence, we often have this triangulation of interests, the state, the defendant, and the victim. So, and often, sometimes those interests don't align and are different between each other. So one of the pieces of evidence that you mentioned, audience, in your list there was perhaps the audience of an eyewitness, of a witness to give evidence. And I mentioned the security guard. Of course, George might want to give evidence as well and just say that, for example, that he simply forgot to pay for the adult diapers that he needs so desperately. So in the adversarial trial, particularly in criminal cases, the most common way in which evidence is produced by the court is through oral testimony, as Ashley said. And as part of that process, you might have seen on television that witnesses are questioned, aren't they, by, first of all, a prosecution lawyer or barrister or advocate, and then the defence will be able to ask questions in cross-examination. All that is governed by the rules of evidence, what can be asked, how it can be asked, and so on. One of the things that the defence advocate will be very keen to do with our security guard is to perhaps challenge the credibility of the witness, right? So, Jeremy, what do we mean when we are talking about the credibility of a witness?
So when talking about credibility, we're essentially talking about how worthy they are of belief, right? And also how well do they come across when giving their evidence. So an advocate will challenge that credibility in a number of different ways.
And how do we do that? How do we impeach their credibility? Well, we can do it in a number of ways. You could suggest that the witness has problems of perception, poor vision, poor visibility conditions. Let's imagine the security guard, there might have been a shelf in the way and they might not have had a good view. You may suggest that they've got problems with their memory, that it happened so long ago. How can you be sure he put the diapers in his bag? You know, you sure you're not confused about that? You might suggest that the witness isn't rationally communicating what happened, perhaps using another person's words, or perhaps they've been influenced by somebody else when making their statement. You could suggest that they are lying. That's obviously quite a bold assertion to make, but you could nevertheless just say that they are lying. And you might want to do that because they are biased. You could perhaps suggest that they are biased, that they've got a relationship with a certain witness. You may suggest that a witness has made previous inconsistent statements before. And this is a very usual technique in the trial, is when you'll be pointing to the fact that when they said something to the police, it was different to what they're saying now. Or the other way around, they might mention something now that they never mentioned before. So you can challenge that consistency with the witness. You then may also suggest that they are of bad character, which could go to a particular issue itself, or suggest that they are simply not worthy of belief at all. So that's what I want to pick up on, is this issue of bad character. And in a minute, we're going to talk more about what that means. But I think, as most of us will appreciate, that, for example, if someone has got previous convictions, let's imagine someone who has been in trouble with the police before, they have been convicted in court before, or they pleaded guilty. Now, as far as the law's concerned, we would call that person someone who has bad character. So the law of evidence, there is a whole category of what's called bad character evidence. Obviously, the opposite of that is good character, somebody who has never been in trouble with the police before and has never been convicted, can rely on their good character in certain ways. We won't need to go through all that today. But let's think about this. Let's imagine for a second that, going back to our shoplifting story, let's say he says he's not there. He says he was somewhere else. The security guard say is mistaken. That's what he's made the wrong identification. And the CCTV footage wasn't very good. It didn't cover the angle very well, and you couldn't see anything. Here's a moral question for you, members of the audience, and I'm going to invite a vote in a minute. Should the trier of fact be told that George has a previous conviction 2 years ago for shoplifting? What do you think? Do you think it's right that the jury should be told that George has a previous conviction for shoplifting? So I'm going to ask Katie to put our first poll up. So here is an opportunity for you to vote, yes or no. And if you want to, you can put your reasons in the chat as well. And guys, if you could have a look at the chat for me, because I can't see the chat while I'm showing my screen. So if you, if anyone asks a question or anything that you think is important, please do pipe in, because I can't read it. Okay, so let's have a vote there. Do you think, should a jury be told George has a previous conviction for shoplifting? Oh, yes, I can see my chat now. Okay, all right. Interesting. Okay, giving you 10 seconds to vote. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. And the results are yes 75%, no 22%, or 24 people say yes, 7 say no. Well, and some of the comments I see, people who said yes because he could have a natural proclivity to steal or shoplift. Someone who said no because people can or should be allowed room for growth and there should be no pre-existing bias for the defendant. So there we go. Oh, someone's asked, by the way, is this criminology or part of a criminal law module? No, it's actually a separate module. It's called the Law of Evidence, and it's an optional module for would-be barristers, lawyers, it's that sort of thing. So it has a criminal slant, but you also do a bit of civil as well. And then someone else thinks, yes, the jury should know everything there is to know. And someone else says no, because it could influence the jury's opinion. So very mixed bag of views there. Majority, they think it should go in. Well, the issue here is that in the past, the position was that it was not permissible to bring in the defendant's bad character. And the reason for that was, just as someone said in the chat, that it was felt that juries and fact finders might be so blinded by that past behaviour that it might then prejudice the jury's mind against the defendant. But due to politics, the country at the time, there was a much more victim-centric approach by the then Labour government, who, following their white paper Justice for All in 2002, decided that an overhaul was needed, was long overdue, and therefore they did make it much easier for bad character to be introduced against a defendant, but also made it more difficult to adduce bad character against a prosecution witness. And crucially, it also gave a very wide definition of what bad character means. So no longer is it simply that George has got a previous conviction. Listen to this, Ashley.
So the definition of bad character is found in Section 98 of the Criminal Justice Act 2003. And it states that bad character is evidence of or disposition towards misconduct other than evidence which A, has to do with the alleged facts of the offense which the defendant is charged, or B, is evidence of misconduct in connection with the investigation or prosecution of that offense. And the Act further goes on to define the terms misconduct in Section 112, which is considered commission of an offense or other reprehensible behavior. And commission of offenses refer to previous convictions, previous offenses for which the defendant was not previously tried, and evidence he has committed an offense that he has since been acquitted of.
Okay, so really widening here. Think about it. Not only can a previous conviction now come in, but also previous offences for which you've never been tried. Also, if it's relevant, evidence of an offence you've committed when you were actually acquitted. And also, of course, there's this phrase, reprehensible behaviour. So reprehensible behaviour hasn't actually got a definition in the Act, and it's been ruled to have a very wide definition. It could be anything from, oh, I don't know, cheating in an exam, or somebody who simply has a reputation for being dishonest, but they haven't actually done anything before. They might just have a reputation for it. So this phrase reprehensible behaviour is being given a very wide, broad definition, could be anything. And the benefit of that is, of course, is that what's reprehensible today may not have been reprehensible 10, 20 years ago. And indeed, it might not be reprehensible in 10 or 20 years' time. So it is very much of the moment. And of course, the issue is who decides on what is reprehensible will be the judge deciding on admissibility. And so those people who came perhaps to our first webinar in this series, when Erica Rackley and Kirsty Horsey were discussing, the importance of who our judges are and does it matter? Well, this is an example of where it could matter, and we'll touch upon this again later on in the webinar. So what we want to do is let's have a little test. Let's see how reprehensible you think you are compared to what the courts think. So let's play a game called How Reprehensible Are You? Okay, right, so in a minute, We're going to give you some scenarios and we want you to vote as to whether or not you would say that is reprehensible behaviour. There we go, cut music. Okay, and then we will tell you what the court said. So let me give you an example. The first one, taking drugs. Okay, is taking drugs reprehensible in your view? And we're not talking about paracetamol, we're talking about illegal drugs. And of course, there's a big debate as to whether or not cannabis should be legalized or not. At the moment, it isn't. It is an illegal drug, so we include cannabis in this. So is it reprehensible to take an illegal drug? Vote now, yes or no. Jeremy's smirking. Okay, 3, 2, 1. Let's see the result. Oh, okay, 66% think it is reprehensible, 34% think it isn't. I'm quite surprised about that. I was thinking that more people would think it was reprehensible. Wouldn't you, Jeremy? What do you think about that statistic?
Changing attitudes.
Right, okay, changing attitudes. So everybody, okay, drug addicts, fine. Okay, what about the next one? Here we go. Well, the answer was yes, agreed. The court agreed with you, yes. Taking drugs is reprehensible behaviour. What did the court say? Do you think? Well, what do you think? And then what do we think the court thinks? Being addicted to drugs. Is being addicted to drugs reprehensible? There you go. Yes or no? Is being addicted to drugs reprehensible? You know, it's not their fault. They're addicted. You know, it's like how graduates are addicted to hard work. The question is, are they addicted to drugs? All right, 3, 2, 1. We'll finish that one there. And the result is, okay, interesting. 59% say no. Guys, what's the answer? Do you remember? Probably not. Well, the difficulty here is, think about it logically. If you are addicted to drugs, what do?
Take drugs.
You take drugs. And the court's already said that's reprehensible, right? So of course the court's going to say it's reprehensible. Because in order to be addicted to drugs, you're going to have to take drugs. So that's why they say yes in the case of Donnelly, that being addicted to drugs is reprehensible and therefore is bad character under the law. So those who voted for getting George's conviction in here, you should be supporting this, right? Right? I suppose so. Having an interest in swinging parties and in carrying out public sexual acts in camouflage gear with a night sight. Okay, yes, that did go to court. Someone's asked a question here, but this is an interesting one. Here we go. What if you're addicted but in rehab where you don't have access to drugs? Sorry, it's still bad character. You shouldn't have got addicted in the first place. That's the court's view. Is addiction not a medical condition? Not when it's illegal drugs. It's no, arguably, you know, this is where the law is quite harsh compared to other things. You know, you have other issues to think about, you know, societal issues here, but the law sometimes is not forgiving, particularly in bad character. Okay, so here we are. Is having interest in swinging parties and in carrying out public sexual acts in camouflage gear with a night sight reprehensible? Yes or no? What's the vote? What's the result there, Katie? Yes. So more people think it's reprehensible to have an interest in swinging parties and camouflage gear than it is to actually have a drug addiction. Interesting. Well, the answer the courts came to was yes, it's reprehensible. Bit prudish, but nevertheless, they said yes, it is reprehensible behaviour. So another one, displaying racist and aggressive behaviour on film. Let's see, can we have the vote up on that one? No, I think this should be quite straightforward, guys. This should be an easy one. Do we think that displaying racist and aggressive behaviour on film is reprehensible? Bad character. Jeremy, don't give it away. Don't give it away, Jeremy. Can't help yourself. What's the answer, guys? Let's have a look at the vote. Yes, of course, 93% said yes. Bit worried about the 2 who said no. Come on, guys. Yeah, and that was the case of course, bad character was used in the case of David Norris, the Stephen Lawrence murderer. In his case, bad character was able to be adduced under these provisions, and the fact that he was displaying racist and aggressive behaviour on film was, of course, relevant in this case to motive and the racial attack. What else have we got? Taking and collecting pictures of people slapping each other. What do we think about that? Is that something that's going to be reprehensible? Should that not happen? Sounds a bit mean, doesn't it? What if it's a joke? Should it ever be a joke? Think about it. Judges are, when they've got these questions to answer, they are making an assessment of life. They're making an assessment on people's morals. They're making an assessment on people's behaviour. And sometimes we may not agree with their assessment. Is taking and collecting pictures or film of people slapping each other reprehensible? Our jury said, and the answer is no, 52%, yes, 48%. So more of you think no, it is not reprehensible behaviour doing that. Okay, well, I'm afraid the courts disagree with the majority there. The answer is yes, it is. The case of Salim was a case in which evidence of that happening was used in the trial to show the propensity, the behaviour of the defendant. Having a mental illness. Is having a mental illness reprehensible? Is that bad character? Now, is that the defendant's fault there? Or witnesses, because of course this could apply equally to witnesses. Is having a mental illness reprehensible? Hopefully another quick one for you. Easy answer here, yes or no. And our jury say no, 88%. Quite right. It is not reprehensible behaviour. Crown against time makes that clear. How about this one? Last one. Being sexually promiscuous. Sexual promiscuity, having a lot of sexual partners. You would think that that shouldn't really matter, should it? It's up to you how many sexual partners you have, isn't it? Or is it reprehensible to be sexually promiscuous? What do you think our judges said? What would you say? Is being sexually promiscuous reprehensible or not?
See the little smirk that came out of Jeremy?
Getting in trouble today.
Oh dear. And our jury said no, 74%. And what did the court say? The court said yes. Now, at this point, I imagine some of you will be shouting at your screens, yelling, throwing things, and so on. Ashley, when you found this out, did you get a bit angry about it? That sexual choice and promiscuity was bad character?
I mean, yes, because what does my sexual behavior have to do with who I am as a person?
Absolutely right. Yeah, you're absolutely, and indeed, this is it's actually in the news, isn't it, this week, when you saw about the rape conviction issue, and Boris Johnson was asked in Parliament parliamentary questions about the fact that rape victims, sexual assault victims, are having allegedly sexual behaviour introduced into court. Well, this seems a very strange decision, but actually it's logical. And the reason why is because under other pieces of legislation, so under the section 41 of the Youth Justice and Criminal Evidence Act, there is something called the Rape Shield, and that protects witnesses and victims of sexual abuse from being questioned about their sexual behaviour, unless it is really comes in under one of the very, 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 very tight exceptions. On top of that now, however, the bad character regime adds another layer of protection. Because the court has viewed sexual promiscuity as bad character, it means therefore that for the defence to cross-examine on it, they will also need to satisfy an enhanced probative value test. And the argument always is, well, where is the probative value in knowing whether or not a complainant has slept around a lot. It's irrelevant to the issue in the case. So actually, you may think that decision is bonkers, but actually there's some logic to it. So don't start yelling too much. Okay, so this now leads on to drill and rap music, another thing that really is hitting the news lately. There is a question in society whether the drill music phenomenon is partly responsible for the rise in gang and knife crime, or whether it is simply art reflecting on real life. And in February 2021, a report was published by Youth Justice in which it identified that the misunderstanding of drill music as an incitement to violence was contributing to the overrepresentation of minority ethnic youths in the criminal justice system. But as our students will go on to analyse, the courts do not see it that way. So drill and rap music, if you don't know what it is, this is a little clip.
Bit first on talk, on flight mode when we walk. Get the drop, then he's caught. Ski out when he falls. Came up selling draws. I'm serving cats from a pool. Cut the green like a lawn. Shiny piece when I walk. Bit first on talk, on flight mode when we walk. Get the drop, then he's caught.
Yeah, so that piece of music was in 2018 used in a criminal trial involving the Rayners Lane gang, who were having problems with another gang, and a young man was stabbed, and then this song came out, and the prosecution successfully used that song in order to infer gang crime on the defendant. They were able to use it. And if you listen to the lyrics, and you can see it referred to in that press article there, dip is referring to stabbing and so on. And so the argument is that this music is relevant as bad character evidence. That's why this issue has arisen. And from the commentary and case law, the reason why prosecutors want to use this evidence is to show gang membership, to show a confession or admission, to rebut an innocent explanation, to show knowledge, because the clip might reveal that they actually know how the murder was committed, for example, and also to show propensity to be violent. So they're the reasons why prosecutors want to use this evidence. Now, the argument that the academics argue, and this is a big issue of controversy in academia, is that according to, for example, Abena Owasabempa, who has written studies on this, her view is that even a cursory review of the case law suggests that on the whole, the courts have taken an uninformed and dismissive attitude towards the prejudicial effect of rap music, which vastly overestimates its probative value. So going back to what Ashley was saying earlier about the probative value versus prejudicial effect, her view is that introducing rap music, because it is written often by young black men, that they are being targeted, inviting literal interpretations of that rap music with little or no appreciation of understanding. It's too prejudicial. Juries are just going to think that that is evidence of bad character without looking at the probative value of the evidence. Ethne Quinn, in her study, she points to the dangers of this type of evidence and points to the fact that expert evidence relied upon often comes from police officers themselves. And indeed, the Metropolitan Police are taking this very seriously. They've actually set up a specialist unit whose job is to trawl through YouTube looking for gang videos, right? They're looking at drill music, they're looking at gang music, and so on. And then we have a Canadian academic as well. And indeed, this is happening in Canada, in the US as well. And this is the only art form that is in effect being policed so heavily. What effect does this therefore have on the fairness of the trial? And you remember I mentioned earlier about how Article 6 should also be used in conjunction with other articles. There are two important ones to mention. Article 10 is a right of freedom of expression. So that's the right that gives us the right to protest, gives us the right to write things, what we want, to express ourselves. And then we have Article 14, which says that the enjoyment of all the rights and freedoms shall be secured without discrimination on any grounds such as sex, race, colour, language, religion, political or other opinion, national social origin, association with a national minority. So to look at those questions, some of our students, 4 of them here, participated in a moot which posed that question, you know, the difference between Article 6 and Article 10 and 14. Ashley, could you tell us what a moot is and what this particular moot was about?
Okay, so a moot is a simulated court hearing in which the students take the roles of the advocates, with one pair representing the appellant and the other side representing the respondent in a pretend appeal. Kent Law School has a full mooting program, and we have visiting practitioners and judges who sit as a panel to hear your submissions. So the case we did was a made-up case called Crown against Anthony Obi. He was charged with possession of a firearm with intent. He allowed drill musicians to have recording sessions in his house, as he was a fan of the music despite like the violent nature of it. However, some of them also turned out to be gang members who had had an altercation with the police involving firearms and were subsequently arrested, charged, and convicted of possession with intent. Then, about a year later, police realized he hosted them in his house, and upon a search of his house, they found one of the firearms used during the altercation hidden away. So, that coupled with his own extensive collection of drill music led the police to infer that he was affiliated with the gang, and so he was charged with possession with intent under joint enterprise rules. And so our relevant ground of appeal for today was whether a court acted in breach of Articles 10 and 14 of the European Convention on Human Rights when, in a criminal trial against a Black defendant, it admits drill or rap music pursuant to Section 101 of the Criminal Justice Act when the music in question has been recorded over 12 months before and does not refer to the facts of the offense.
So Ashley, you were for the appellant and so arguing in support of that ground, as were you, George. And George, perhaps could you briefly tell us what your main points and submissions were then in the moot? And if anyone has any questions about rap music and drill music in criminal cases, do put them in the chat. Or if you want to clarify something that any of our speakers talk about, just drop us a message in the chat there. Go on, George, what did you argue then? How did you argue this?
So the way my submissions I presented to the Supreme Court was essentially a list. So the first submission I made was, as a matter of policy, the admission of rap or drill music as bad character evidence offends Articles 10 and 14 of the ECHR. And my grounds was that through precedent, freedom of expression in a democratic society also constitutes matters that offend or shock the state. It's not just things that the state appreciates. And the second ground I had was that academic literature, following your previous slide, specifically Dr. Owusu Bempha, signifies that prosecutors are playing into a racist stereotype of young Black men by using this evidence to illustrate reprehensible behavior. Now, my second submission was that if the Supreme Court found that this evidence doesn't actually offend Articles 10 and 14, then there needs to be a test. And so the ground I used was the test set out in the case of Crown against Lewis. I submitted that this should be the main test, and that the trial judge, in our case, incorrectly applied this Lewis test with the case of Crown against Alimi. Now, since 2002, when the legislation was passed, there's been 17 cases involving rap or drill music on young Black defendants, and only one case was successful. That was Crown against Alimi. So I made sure I applied that in my submission. And then finally, in addition to making the Lewis test the mandatory test, I also said, as a matter of policy, rap or drill music under Section 101 should have additional scrutiny over the context of the evidence in relation to the jury. So I argued that trial judges should provide more guidelines to jury so they avoid conclusions of bias. And the requirements to be called as expert evidence for police officers should be added, and this test should be applied.
So Ashley, when you were looking at your research, and I mentioned earlier about the importance of judges, and we saw that in our first webinar in this series about how important our judges are. What struck you about that and this aspect of the law?
So I think what stuck out most to me is, like, in first year, the first thing we learn about criminal law is it was basically created around the harm principle, you know, to criminalize acts that would be harmful to general society. But there is no strict definition of what these principles are. They're decided by the lawmakers and the judges. But when you look at it now, the type of judges we have, it's a very white male cis heteronormative, you know, panel, both whether within parliament or within the actual judiciary. So it's their views that are being used to determine what is harmful or reprehensible behavior. So for example, in first year, I remember that one of the first cases we did was Crown against Brown, and it was a 90s BDSM case. So
BDSM, better explain that to our viewers in case some of them don't know.
I feel like some of the viewers might know more than me, but BDSM is sadomasochism. So it's people who derive sexual pleasure for either inflicting or receiving pain. And this case was about like a group of men who were extremely sadomasochistic, till you don't even know the details, but it was consensual. They did it amongst themselves and they enjoyed it. But the thing is, they were convicted of it because despite it being something they did in private consensually, the judges saw their sadomasochistic homosexual acts as evil, because these weren't things that were accepted in those days. And because of that, they were convicted up till the highest level of the Crown Court, because their acts were considered evil. And coming forward to now, in present day, we have obviously more understanding of both subjects. But when you now look at it within the context of the rap music, it's these same judges who don't understand the cultural influences, stylistic devices used in rap music, making those decisions. And because those violent lyrics offend them, then they decide it's reprehensible behavior, despite what was held in Handyside v. United Kingdom that stated freedom of expression didn't just apply to good or acceptable information, but also information that shocked or offended the state. But in this case, they've decided that since rap music, they don't understand it, its lyrics are no more violent than country or heavy metal, actually less violent in a lot of cases. But because it's something they don't understand, to them, it's reprehensible. So reprehensible behavior is really in the eyes of the beholder. And with this white male cis heteronormative society, that really poses a danger for Black defendants who are charged under this rule.
And there was something in the academic literature. There was a study in the US where they actually did a blind test, didn't they? They took lyrics that were just standard lyrics from a drill music, and they gave one set of participants of the test the lyrics and said, right, this comes from country music, just normal country and western music. And then to the others, they said it came from drill and rap music. And they asked them for comments from each group, and automatically more people from the people who were told it's drill and rap music immediately gave it a negative connotation, immediately said that this is violent, that this is etc., gang related. Whereas most people from the country music said, oh, it's just country music. Yeah, so there's ingrained in that, there's already their prejudice. So Jeremy, you represented the Crown, so you were the respondent, and you had to argue the opposite. So how did you go about it?
So obviously I had a very uphill battle, but I started my argument by demonstrating that this type of evidence was not discriminatory because it served a legitimate purpose to help the prosecution and victims. So according to the ECHR, your Article 14 rights are not violated for being treated differently if it's being done for a legitimate aim or in proportion to the objective. And so national governments like Westminster's Parliament are the best judge of what's considered a legitimate aim or proportional. So Parliament created this piece of legislation that allows this type of evidence to be used, and they've said that it's proportional. So I then looked at academic research that studied how gangs make rapid drill music and videos. And the research I found discussed how these gangs use the videos and the lyrics to communicate threats, promote themselves, and show off their possession of drugs or weapons. Frequently in these lyrics, they call out rival gangs, talk about their own turf or themselves as a gang. In the videos, the filming locations are really important. They normally film in their own territory, but on occasion, in order to taunt an opposing gang, they'll film in a different, somebody else's turf, essentially. And they don't just allow anyone in their videos, they only allow either members of the gang or people that they really trust that are associated with the gang. So I looked at the same case that George had discussed, the Crown against Lewis, and showed how they were able to identify the defendant as being a member of the gang by showing their presence in the music video. And also in another case, in the Crown against Sode, the defendant was showed to be a member of a rival gang, which provided evidence as to why they would want to kill the victim in that case, who, like I said, was a member of that opposing gang. Then in the third part of my argument, I looked at how, as we mentioned earlier, media of people expressing themselves in court has been used not just in drill or rap music. So we mentioned the case of the Crown against Norris, where essentially a white male had been expressing racist views, and this video recording of him was made after he supposedly had allegedly killed this young black male, and the video recording was admitted as evidence and helped to convict him. And then finally, I looked at the case of the Crown against Alimi, where a judge refused to allow this type of evidence. And that was essentially just to show that they don't always allow it in, although they do frequently allow this type of evidence, basically trying to demonstrate that judges are able to weigh the prejudicial effect against the value of this type of evidence.
Okay, well, one of the comments in from the chat is that this really shows how important social and cultural context is, and they've got the message that we're trying to send out there in one sentence, haven't they, Ashley?
Yeah, because I was actually just thinking of the example, seeing as two of our panelists are Canadian, the example of Drake. So most people obviously know Drake, and in a lot of his music, he'll talk about so it started from the bottom, shooters, what, and he grew up in Canadian suburbs as a child actor. Like he did not start from the bottom. He was not involved in gangs and shootouts, yet he sings about such things. It's just a form of artistic expression. Or even J. Cole, who had this song, For Your Eyes Only, that really went into depth about gang life, but he wasn't rapping it from his perspective. There have been reports that it could have been from a friend of his who passed or just a persona he took on. But the point is, it was just a form of artistic expression, not a narrative of their lives. So if you understand the cultural context of the music, you know a lot of it is just an exaggeration, just a form of expression. But it doesn't necessarily mean that that's what's going on, or listening to it doesn't mean that you agree with everything there, you know?
Because of course, recently, the first time a number one hit in the UK is a piece of drill music. Do you reckon that's a sign that things might change? Of course, you then also see the award-winning, BAFTA award-winning documentary on Digger D. You might have noticed that as well. And of course, he's received so many orders. His rap music and drill music is actually policed. He has to get approval first from the police for his lyrics, or he goes back in the slammer, because he did a term in prison for a fray, didn't he? So, where is this where do you see this happening? From your research and what you've read about it, do you, what sort of points do you think and arguments did you come up with to say that, is this going to last, or do you think, as society changes, reprehensible behavior definitions will change and so on? What do you think?
Well, I think it's definitely interesting to note that it's not just rap. We have seen cases both with like skinhead punk rock. There's been matters in Norway, like Norwegian black metal bands burning down churches that then wrote songs about it, and that was used as evidence against them. And again, going back to an example from Canada, I understand the reference actually made to Drake, but for instance, there was another case called the Crown against McCullough, where essentially the defendant wrote detailed lyrics about he murdered someone, like the process of stabbing them to death. And all of the lyrics that they wrote in this rap song, which was admitted to the court, was basically the forensics showed that was the exact way that the guy got killed. So it definitely needs to be handled on a case by case basis.
But to counter what Jeremy has said, the examples he's given of music that wasn't rap or like non-black defendants, in those cases it was the actual perpetrator specifically who did what they're being charged with or accused of. But when it comes to rap music, it's not just who is singing the song. It's literally like in the Sode case you mentioned, the defendant just appeared in the video. In the case we did, the defendant just loaned his house for use. The Limi case, the one case that he was like set free, it's not that he was set free from the get-go, it's upon appeal that now higher courts decided, yeah, this is too extreme. But even in that case, he just appeared in the video. And the issue with that is because the UK has an extremely racialized concept of gangs. Because you tell someone gang, they immediately think of young black men. So with the music, they don't just take who sang it, they take anyone associated. You could literally be family or known someone forever, have no affiliation to the gang related activities itself, but because you're around them and because in our eyes gangs are just a whole group of, you know, young black men, you will be lumped together with them for any association, even as minor as similar musical preferences. And that's the difference with how they treat rap music versus how they treat other music.
Okay, so Ashley and George, you wouldn't disagree completely with Jeremy's point that if it's specific, it's been written straight afterwards or just before, and it specifically refers to the crime, then yeah, that's fair game. But Ashley's more general point is that the case law, the 17 cases George referred to, a lot of them, the link is very tenuous, very narrow, and that really is too prejudicial. The probative value is outweighed in those situations by the prejudicial effect. Go back to basics, yeah? Have I summed it up?
Yeah.
Yes. Well, on that note, ladies and gentlemen, we have nearly reached the end of our time. So thank you very, very much for listening to us. If you do want to learn more about this area, then there's a couple of links here. There is the documentary about defending Diggity that you might want to watch. There's also a blog, the International Forum for Responsible Media have done a very interesting story about this. And also there's the Garden Court Chambers have done a very interesting series about this issue. So that's all available. Do take a look for it, have a search for it. And of course, next, if you want to keep up to date with our news, we've got our information there. And also next week, it's Can Employment Law Cope with COVID? With Professor Lydia Hayes and Professor Diamond Agbor, who is going to be looking at whether or not it's right that all workers are not equally protected by employment law during COVID. So I think that's all I wanted. Was there anything else in the chat? A lot of people saying thank you. Excellent. Well, thank you guys for that. When do you find out your results?
Next Thursday.
Next Thursday. Well, fingers crossed for you all. I hope that it all goes well with your results and you then go on to do what it is you're going to go on to do. So good luck. Thank you ever so much. Thank you everyone for listening. Do tune in again to another one of our Summer of Law webinars. We hope you're finding them useful and we look forward to seeing you someday in Kent. Okay, goodbye everyone.